This past week, I had a very interesting question from one of my longtime clients. In fact, we had helped her get a green card. But at this stage in the game, she was divorced from the individual. It was a temporary green card, good for 2 years, and she wanted to know if it was still possible to file the I-751 even though she was divorced, and what would be her chances of success. And this was my answer. Yes, it is definitely possible to file your I-751 petition to convert the 2-year conditional green card to a permanent 10-year green card, even if you're divorced. In fact, the documentation is identical. Whether you're still married or you're divorced, the documentation is identical. This, I said to her, in theory, if you were still married but had very weak documentation, even though you were still married, immigration would not approve the I-751 petition. Conversely, if you were divorced and you had very strong evidence that it was a real marriage, and you had many documents that were issued jointly, whether it's insurance, bank accounts, 2 names on a lease previously, perhaps a child that you had in common, this would be perfect evidence of a bona fide marriage, and the fact that you're divorced would have no bearing whatsoever. The only other piece that I wanted to mention is that if you are divorced and you were married, you were living together a very short period of time, but the divorce occurred because of abuse, if you can demonstrate the abuse through police documentation and court documentation, that is one exception to needing 2 years of full documentation. I hope you found this information helpful, and I would be happy to answer questions about this topic or any other immigration topic. Feel free to call my office in Morristown, New Jersey. Thank you.